What I talked about was a study by Cornell law professors Stuart Schwab and Kevin Claremont, and they looked at a 30-year data set held by the Federal Judicial Center, tracking how employment cases fare. And their analysis showed this: when employers win a trial, they are reversed 8% of the time, which personally I think makes some sense because there's deference to the fact finder, there's intent involved, there's circumstantial evidence. But there are shocking numbers when employees win a trial. When employees win a trial, they are reversed 41% of the time. That is a 5-to-1 disparity with the employer trial victories. And you have to look at what these employees have done. These are courageous people who have able counsel of cases of substantial merit. These are cases that have survived this lawyer screening before being taken, on contingency usually. They have survived pretrial motions, including summary judgment. They've convinced a fact finder at trial, and keep in mind that juries favor the employer 63% of the time in employment discrimination cases. So they've convinced those fact finders in the 33%, okay? And then when they go up on appeal, they have their cases reversed 41% of the time. And the evidence analysis we've done anecdotally has shown a lot of times that there's a change in the legal standard that robs these employee trial victories, such as what happened with Lilly Ledbetter, the Supreme Court litigant. And that causes me, and I think many others in the bar, a tremendous amount of concern. Lilly Ledbetter is such an extraordinary person with an extraordinary situation of getting Congress to act. But for most employees, most litigants, it's the U.S. appellate courts that is the final say. And what I testified in front of Senator Leahy in the Judiciary Committee in September, and I called on them to really consider a much wider net of candidates for the pools that are being considered for the U.S. appellate courts. Well, there's the Civil Rights Act of 2009 that is being considered that would be, again, addressing some runaway Supreme Court decisions that violate really the intent of Congress. I think what we're seeing is a pattern where Congress wants civil rights to be vindicated. Congress treats civil rights as a sacred area. The Supreme Court, in many instances, not in all instances, really has technical grounds to roll back civil rights. But whatever people's view of the Supreme Court, the U.S. appellate courts are much more hostile. The Supreme Court's actually reining in the U.S. appellate courts often. The U.S. appellate courts are extremely hostile. The data shows that. The data shows that, and then the sample of cases I've done from surveying practitioners shows what I call moving goalposts. My firm's website is findjustice.com, FINDJUSTICE, the word justice, good word. Findjustice.com is you'll see the testimony. If you look under my bio, Cyrus Mehri, M-E-H-R-I, you'll find that kind of information.